Welcome to the Friedmann Firm Podcast, Ohio Employment Law Guide.
Welcome to the Friedmann Firm Podcast, Ohio Employment Law Guide with attorneys Rachel Sabo Friedman and Peter Freeman, co-founders of the Friedmann Firm. Rachel and Pete are plaintiff-side employment lawyers who represent workers across Ohio in cases involving discrimination, retaliation, wage violations, and other workplace issues. They're known for clear, practical guidance and for helping employees understand what the law actually protects and what it doesn't. My name is Leanne Lyon, and today we are starting with one of the most misunderstood topics in employment law, wrongful termination in Ohio. Hello, Rachel and Pete.
Hi.
Hi.
It is so great to be here. And since this is our first episode, can you each share how you got into employment law and what motivated you to build a firm focused on standing up for the employees across Ohio?
Yeah, I can take this. So we started our practice right out of law school together. And in the beginning, we did general practice to try to understand all different areas of law and get a feel for different type of work that we like and what we didn't like. So we did a bunch of different stuff, and that allowed us to get good courtroom experience. We did some criminal defense work. We did some domestic work, estate planning, real estate, and then eventually employment law. And we found that we enjoyed doing employment law the most, mainly because we were representing individuals who had issues and claims against their employer, or may have been mistreated at work, or just needed counseling and guidance through a difficult situation that they were experiencing. And we found that type of work, representing individuals in situations that affect their livelihood and their career, was most rewarding for us. And so that's what we started to develop our niche in and focus more of our attention and time and effort. And then it really kind of segued from there. But I would say maybe for me, I was always somebody that, even as a kid, really didn't like when somebody would get bullied or picked on. I didn't like when other people would feel bad about themselves. And so it always motivated me to be in a position to where not, as a kid, I didn't want that to happen to me myself. But then as I got older and felt a little bit more empowered with my education, that I could use my experience in education to help people avoid that type of treatment in the workplace.
Nice. Love that. Rachel, anything to add?
Yeah, I would echo Pete's sentiments. We started practicing employment law pretty early on in our career, and we were lucky enough to have a great mentor to teach us and guide us as far as how to litigate those cases. We ended up really enjoying it, and I think the part that I enjoyed the most was just knowing that we're helping people, that are in a very difficult situation and don't have a lot of resources or support, because typically it's the little guy against the company. So it feels really good to be able to help in that way. And it's very rewarding.
Well, let's dig into this then. When somebody tells you that they were fired unfairly, how do you explain what actually qualifies as a wrongful termination under Ohio and federal law?
So wrongful termination is a very misunderstood term. It's a little bit of a misnomer. So just because a termination may feel wrongful in Ohio doesn't necessarily mean that it's illegal. So Ohio is what we call an at-will state, which means that you can be terminated for any reason or no reason at all. And the only exceptions to that very generally are typically discrimination based on a protected class and retaliation for what we call engaging in protected activity. So even if a termination may seem wrongful, it really needs to be actually illegal in order for it to be considered wrongful termination in Ohio. So it's kind of a term that a lot of people misunderstand, because I think people think that, if a termination feels wrong or is unfair or there's no legitimate reason for it, that it must be unlawful and therefore wrongful. But that's not always necessarily the case. So it's very complicated and something that most people don't understand until an attorney explains it to them or until they do their own research on it.
Well, as you said, a lot of situations can feel wrong or unexpected or unfair, but they still aren't illegal. So, what are the issues that people most commonly confuse with wrongful termination? And what does the law require before a claim really becomes viable?
So most of the issues that people experience are just some type of disagreement, personality conflicts, mistreatment from management, leadership, or even coworkers that eventually prompt some type of um, report or complaint of harassment, discrimination, anything of that nature. And then that will eventually lead to hopefully an investigation by the employer to look into what situation was, what transpired, what who may have been involved, are there witnesses or anything of that nature. And so usually what we'll see are situations where people are made uncomfortable. Something happens to them at work that results in them experiencing some adverse employment action, such as a demotion or a reduction in hours or termination. And so usually what we'll see is people will reach out to us because of that they experience some form of adverse employment action, and they really want some counsel or guidance as to, is this a violation of the law? Here's what happened to me. And certainly there are times when people lose their livelihood. May have been working somewhere for 5, 10, 15 years and suddenly terminated unexpectedly. And they just, most people would think there has to be some other procedure or explanation or some process that an employer needs to follow in order to effectively terminate someone. And unfortunately, at least in Ohio, that's not the case. Either party can terminate the relationship at any point for any reason or for no reason at all. And so what we have to do is we have to show that if someone is terminated, then they were terminated because of some unlawful, discriminatory, or retaliatory reason. And so that's when we start asking a little more questions about the circumstances regarding someone's termination, what may have prompted it, what the reason was given for their termination, what the reason by the employer was given, and also asking the potential client what they feel is the real reason. Because obviously if there's a company or leadership discriminating against somebody or retaliating against somebody, they're not going to acknowledge that that's the reason they're terminating the employee. They're going to more than likely try to come up with some other reason for justification.
Well, when a termination involves discrimination, whether that's ability, race, gender, pregnancy, age, or other protected category, what tends to matter the most in determining whether somebody actually has a claim?
Typically, it's evidence. So as a person bringing a claim against an employer, you're the plaintiff and you have what's called the burden of proof. So you have the burden of proving that there is evidence of discrimination. Um, and it's a relatively high standard. So, it can't be, you can build a case on circumstantial evidence, but it's obviously much better if there is some actual evidence of discrimination, whether that be like discriminatory comments or in an age discrimination claim. A good example is if a company gets rid of a lot of its older workers, that type of thing. There's a lot of different examples that can exist, but we're really looking for not just a hunch. Sometimes people will call and they'll say, "Well, I don't know, but maybe it's this," and usually that's not going to be good enough. The standard really needs to be higher than that, and there has to be at least some evidence or some argument that we can make to tie the termination or the adverse job action to some type of protected class, whether that be, disability, a pregnancy, someone takes FMLA leave, that kind of thing. So evidence is really what we're looking for.
To add to that, I would say the type of evidence is also based on the circumstances of the situation. So whether it's disability discrimination, somebody may have been requesting accommodations at work or need some type of changes in their schedule that will allow them to perform their job duties with an accommodation because of their disability. And then if they experience some adverse action as a result of requesting for an accommodation, then there may be a good argument that the termination is related to their disability. If someone's pregnant and they need pregnancy leave or maternity leave, and then suddenly their supervisor or leadership is coming up with alleged performance issues that have never been an issue before. It's circumstances like that we can point to that we can show that would lend toward a discriminatory motive. Same for discriminatory comments or remarks or statements made about people that may be adverse or derogatory regarding age, race, gender, anything of that nature. That is the type of evidence that we typically look for when making a wrongful termination claim.
And where is that evidence often found? Is it captured in video, text messages, all of the above, other areas? How is that evidence collected?
It can really be a lot of different things. It could be text messages, it could be a conversation, whether that conversation is recorded by someone or whether there's a witness to it. It could be witnesses that are willing to either talk to us or provide a witness statement. A lot of things. I mean, one thing that we look for in particular is called temporal proximity. And what that means is the timing between what we'll call a protected activity and an adverse action. And what I mean by that in layman's terms is an example of that would be if somebody takes FMLA leave, that's protected activity. If they're terminated 2 weeks into that FMLA leave, that's an adverse action. And that temporal proximity, that time period, is very close in time. So that raises obviously a red flag almost immediately of, okay, this person was terminated on FMLA leave, on its face, that's pretty good evidence. So then we look to why the person was terminated. And obviously if you get into an altercation with your boss while you're on FMLA or that happened before you went on leave, I mean, you can still be fired for that. But if there's really not a good reason for the termination, then maybe that evidence is pretty good because we would argue, if they didn't take leave, they wouldn't have been let go, that type of thing.
And some other evidence that we look for is comparable treatment of other employees. If our client is being treated differently than somebody else who maybe isn't taking medical leave or isn't taking pregnancy leave. And really, usually what's the best type of evidence is actual documentation, whether it's reporting complaints of discriminatory treatment, or a witness statement, text messages, audio recordings, anything of that nature that we can show would support what our client is claiming is going to be significant, because oftentimes we are encountered with maybe a he said, she said situation, and naturally the employer is in control of a lot of the employees, and people are reluctant to come forward, even if they're being truthful about what happened. They're concerned that they may lose their own job, especially if they just saw somebody else get terminated for maybe what have appeared to be an unlawful reason. So really, it's what we encourage clients to do is if you're experiencing something at the time, report it, put your report in writing, document it. If you need to, write your own notes about a meeting that you had with somebody, or send a follow-up recap email. Hey, I just want to, reiterate, this is what you and I just discussed during this meeting, so that we have real-time, time-stamped information supporting the claims that we would be making.
So without discussing any specific clients, of course, is there a moment from your work that shows how a situation that looked like a simple firing ended up having real legal implications once the facts were laid out?
Yeah, I would say there's a lot of situations that on its face appear to be a normal termination or a reduction in force or layoff. And obviously, not every employer has some discriminatory motive to get rid of people. We appreciate that. There are really good companies that provide good environment and work culture. But there are all, the situations that we see are usually surrounding some type of, I don't want to say rogue supervisor or manager, but somebody who's making a decision adverse to our client that may not necessarily align with the company's core values, but somebody that's acting as the wrongdoer. And so people at that level are usually intelligent enough to know, well, we're not going to say we're terminating somebody because of their age or their pregnancy or their medical condition. we're going to come up with some other reason that appears to be a legitimate reason so that we can justify this if we have to. So if the company's going through a reduction in force, they may rope that person into a layoff. They may start creating performance issues or disciplinary action for that person. So there's a paper trail to justify the termination. So I would say most of the time that we see a termination, it appears like it could be a legitimate reason, because most employers at this point know they're not going to be able, you can't say we're terminating somebody because of a protected class. So they're very likely going to come up with some alternative reasoning to justify that termination.
Well, as we wrap up here, is there anything else you'd like to address on this topic of wrongful termination?
I think wrongful termination is one of the most challenging types of claims that we have, because so many people really do experience unfair, wrongful treatment that doesn't really necessarily mean it's unlawful. And so we see situations where people lose their job, they lose their income, they lose their benefits, and it's a situation that we certainly can empathize with. And you feel sorry for them because it may be due to no fault of their own. But when it happens, and if there's no legal violation, most people don't really have recourse, and they just have to start looking again and get back out in the job market. And if they've been working somewhere for a long time, it's very hard to do that, especially when you're caught off guard with the termination. So really, it's just what we encourage people to do is, if they think that there might be something there, consult with an attorney just to run your situation by 1, 2, 3 different law firms to see what people think and get some feedback. And that way you can at least make an informed decision on whether this is something that should be pursued.
Yeah, and to piggyback on that, I would just say I echo what Pete said. I mean, most employment law firms provide a free case evaluation. So someone will talk to you and do an intake, and then an attorney will take a look at the situation and let the potential client know if they think there's something there or if they think they can help. So there's really no risk to at least reaching out and doing that due diligence to find out if there might be an actionable claim there. So that is absolutely what we would recommend that people do.
Well, great. Thank you so much. And that is it for today's episode of the Friedmann Firm Podcast, Ohio Employment Law Guide. If you'd like to learn more about Rachel, Pete, and the work their firm does for employees across Ohio, visit thefriedmanfirm.com. You'll find articles, case studies, and resources to help you understand your rights in the workplace. Thanks for listening, and remember to subscribe, share, and leave a review so more Ohio workers can find the guidance they need. Thanks, Rachel and Pete.
Thank you.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.